So guys, in this video we discuss an important tribunals which is formed, which is administrative tribunals. What are its characteristic, is objective behind to form such tribunals, and what are the various subject matter covered under this. So guys, hello guys, I am Kartikeya Hundet in a team of LEXIS and Company as an intern programs provided by them in a virtual internship in LEXIS and LEXCLIQ. The purpose behind this video is only for an educational purpose and knowledgeable purpose for any issues related to legal topics or the current affairs. So in this video I discuss on the important topic of the formation of administrative tribunals in India. What are its various objective and characteristic to be formed, and which articles of Indian Constitution deal with this. So the administrative tribunals comes under article with an amendment in the Constitution by the 42nd in the article 323A and 323B of the Indian Constitutions, which provide a construction of exclusive tribunals which deals with the subject matter related to civil servant. So the civil servant matter goes to the administrative tribunals. So the administrative tribunals is a quasi-judicial body and established to avoid a regular court approach by the civil servant. So the civil servant, if there is any dispute, they approach to the administrative tribunals only to resolve their dispute in it, not going from any civil court or regular court which is already in the existence. So the purpose behind this video is that the construction of tribunal is that they are speedy in nature and helpful in nature. Now we discuss what are the procedures they follow. As we know that the tribunals does not have any strict restriction to be followed, imposed on them to follow only these type of procedures. They having a common interpretation of principle of natural justice, but tribunal can interpret their own interpretation of these principle of natural justice. So it cannot be said that the settled principle that the tribunal only work on the principle of natural justice. They work on in that fundamental rules related to such. So since 1947, in 1976 there is a 42nd amendment which says that tribunal function other than the court. So the help in the formation of tribunals. There are three cases which helpful to understand what are the importance of tribunals. First is the Durga Shankar Mehta versus Raghuraj Singh, in which the Supreme Court especially expressed that tribunals are used in Article 136 plays an important roles as they are not treated as a fully fledged court, but they have some inspiration from them or some investment with the judicial as distinguished from the administrative or executive functions. So tribunals having both the judicial mind and executive administrative function within it, so it termed as a quasi-judicial system, quasi-judicial body. So Bharat Bank Limited and Employees is another case where the Supreme Court observed that through tribunals are to be formed to tap the court from the already overburden and helps the exercise quasi-judicial bodies to functions in the way that it helps the court. This does not mean they are fully fledged treated as a court. So another case is Associate Cement Company Limited versus Sarma. In this the same tribunals plays an important role, and how it gives a characteristic test from combined reading of Article 136 and 222, in which the tested basic test is that the adjudicatory, it is an tribunal is an adjudicatory body other than court. First. Second is the power of adjudicatory body must be derived from any statute or statutory rules. The power of adjudication must not be derived from an agreement between the parties. So if the three principle is fulfilled by any body, it comes to be an administrative tribunals. Now we understand what are the characteristics. So the administrative tribunals act as an administrative tribunals comes in the statutory act, comes by the get power from the statutory acts. So it is a quasi-judicial body and performs such functions. If there is any dispute related to the administrative tribunals, once it is settled in the High Court, the person cannot be go appeal in the administrative tribunals because it is settled in the High Court. But they are giving a chance for appeal if there is any dissatisfaction from the tribunals. There is a writ of cessation or prohibition available against the decision of administrative tribunals. So importance of tribunals we already discussed, and objective of administrative tribunal is only to deals with the matter related to the subject matter of civil servant, government service in the service matter. Speedy relief, it provides the government service. The procedure of the special power of tribunal to make their own specific power to perform such functions. So the tribunals plays, the administrative tribunal play an important role. So Article 262 subclause 2 provide the creation of tribunals to adjudicate a dispute related to water of interstate rivers of the valley. So there is a specific formation why there should be tribunals. So in this way we can understand that the tribunals plays an important role and comes under the constitutional right or constitutional power gives to formation of constitutions. So I hope you guys understand what is the administrative tribunal, how it works, and where it gets its characteristic and objective to perform and its enforcement. Thank you guys for watching this video. I hope you are all in good health and please stay safe.